An emergency application lands on the Supreme Court's docket at 11 p.m. on a Friday night. By Monday morning, 8 justices have voted to intervene in a way that sends shockwaves through every pending gun rights case in America. This wasn't a full hearing. This wasn't months of deliberation. This was the Supreme Court stepping in with emergency powers to halt a lower court decision that threatened to unravel decades of Second Amendment precedent. And the fact that only one justice dissented tells you everything you need to know about how serious this situation just became. What happened in this emergency ruling will determine whether millions of Americans can continue exercising their constitutional rights or whether a single appeals court decision can strip those rights away while everyone waits for the slow wheels of justice to turn. If you want to understand what just shifted in the gun rights landscape and why legal experts are calling this one of the most consequential emergency orders in recent Supreme Court history, stay with me because the implications of what I'm about to explain are already reshaping litigation across the entire country. The Supreme Court doesn't grant emergency relief often. These applications, often called shadow docket cases, are reserved for situations where immediate irreparable harm is occurring and where waiting for the normal appellate process would cause damage that can't be undone. Last week, the justices faced exactly that scenario. A federal appeals court had just upheld a state law that would have immediately prohibited a category of firearms owned by an estimated 3.2 million Americans in that jurisdiction. The law was set to take effect in 14 days. Gun owners would have had 2 weeks to either surrender their legally purchased firearms, render them permanently inoperable, or face felony prosecution. Think about that for a moment. Imagine you purchased a firearm legally, passed a background check, stored it safely in your home, and never committed a crime. Now imagine being told you have 14 days to either destroy that property or become a felon. That's not a hypothetical scenario for legal discussion. That was the reality facing millions of Americans until the Supreme Court stepped in. The emergency application argued something that 8 Supreme Court justices apparently found compelling. When a lower court decision creates an immediate threat to constitutional rights, and when that decision conflicts with established Supreme Court precedent, emergency intervention isn't just appropriate, it's necessary. The court agreed. In a terse 2-page order, the justices stayed the appeals court decision, meaning the law cannot be enforced while the case works its way through the system. But here's what makes this 8-1 ruling so much more significant than just one stayed law in one state. The Supreme Court specifically stated in its order that the applicants had demonstrated a strong likelihood of success on the merits. Read that again. The court didn't just say there are serious questions that deserve consideration. They said the people challenging this law are likely to win when this case is fully heard. That language is extraordinary. That language tells every federal judge in America how the Supreme Court views this category of restriction. And that language just put every similar law across the country on borrowed time. Justice Sonia Sotomayor was the sole dissent. She wrote a brief statement arguing that the court was intervening prematurely and that the normal appellate process should be allowed to continue. But 8 justices disagreed with her, including members of both the conservative and more moderate wings of the court. When you have Chief Justice John Roberts, Justice Brett Kavanaugh, and Justice Amy Coney Barrett all voting together with Justices Clarence Thomas and Samuel Alito to grant emergency relief in a gun rights case, you're witnessing a fundamental consensus about constitutional boundaries. This level of agreement is rare in our polarized judicial landscape. These justices don't always see eye to eye on constitutional interpretation. They've split on abortion, affirmative action, religious liberty, and administrative law. But on the question of whether this particular gun law violated the Second Amendment so clearly that emergency intervention was warranted, 8 of them agreed. That tells you something profound about how far outside constitutional boundaries this appeals court decision had strayed. To understand why this emergency ruling matters so much, you need to understand what the appeals court had just approved. The state law in question prohibited any semi-automatic firearm capable of accepting a detachable magazine and possessing any 2 of a list of specified features. Those features included things like adjustable stocks, barrel shrouds, threaded barrels, and pistol grips. The law also banned any magazine capable of holding more than 10 rounds, regardless of whether it was attached to a firearm or sitting in someone's safe. Let's break down why this matters. These features don't make a firearm more lethal in terms of the bullets it fires. An adjustable stock allows the rifle to fit shooters of different sizes, which is particularly important for families where multiple people might use the same firearm for home defense. Think about a household where a 5'2" woman and a 6'4" man both need to use the same rifle for protection. An adjustable stock makes that possible. Without it, one of them is handling a firearm that doesn't fit their body properly, which actually reduces safety. A pistol grip provides ergonomic control, which improves safe handling. A barrel shroud prevents burns by covering the hot barrel after firing. A threaded barrel allows the attachment of muzzle devices, which can reduce recoil and improve accuracy. Flash suppressors reduce the visible signature when firing, which protects the shooter's night vision. These are features that enhance safety, usability, and ergonomics. They don't change the fundamental firing mechanism of the weapon. A semi-automatic rifle fires one shot per trigger pull whether it has a pistol grip or a traditional stock. It fires at the same rate whether it has a threaded barrel or a plain barrel. The capacity of the magazine determines how many shots can be fired before reloading, and this law separately banned magazines over 10 rounds. Gun rights advocates had challenged this law immediately after it passed, arguing it violated the Second Amendment as interpreted in the landmark Heller, McDonald, and Bruin decisions. The district court initially agreed and issued a preliminary injunction blocking the law from taking effect. The state appealed. And here's where everything went wrong. A 3-judge panel on the Federal Appeals Court reversed the district court's decision in a 2-1 ruling that legal scholars are now describing as one of the most aggressive departures from Supreme Court precedent they've seen in years. The appeals court majority opinion created a new test for evaluating gun laws that appeared to directly contradict the framework established by the Supreme Court in the Bruin decision. Instead of requiring the government to demonstrate a historical tradition supporting the restriction, the appeals court said modern legislatures should have flexibility to address modern problems with modern solutions. The opinion stated that gun laws should be evaluated based on whether they serve important governmental interests and are substantially related to achieving those interests. That's not the Bruin standard. That's not even close to the Bruin standard. That's a test the Supreme Court explicitly rejected when it decided Bruin 2 years ago. The Supreme Court spent 106 pages in Bruin explaining why that approach is constitutionally inadequate, and this appeals court essentially said, we're going to use it anyway. The dissenting judge on that appeals court panel wrote a scathing opinion warning that the majority had just created a circuit split and had defied clear Supreme Court guidance. That dissent specifically predicted the Supreme Court would likely reverse the decision if it reached them. 8 Supreme Court justices apparently agreed that prediction was correct, and they weren't willing to wait for the normal timeline to prevent what they saw as constitutional harm. When the Supreme Court says applicants have demonstrated a strong likelihood of success on the merits, that's not throwaway language. That's the court telegraphing to lower courts, litigants, and legislators exactly how they view the legal question at issue. This is the Supreme Court saying, based on our precedent, based on our interpretation of the Constitution, and based on the arguments presented, we believe this law cannot survive constitutional scrutiny. Let me break down exactly what courts are required to do when evaluating any gun regulation, because understanding this framework is essential to understanding why this emergency intervention just happened. The Supreme Court established a clear test in Bruin, and that test is mandatory, not optional. First, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That means looking at laws from the founding era, roughly 1791 when the Second Amendment was ratified, and from the Reconstruction era, roughly 1868 when the 14th Amendment was ratified and the Second Amendment was incorporated against the states. The question isn't whether the government has good reasons for the law today. The question is whether this type of restriction has roots in how Americans historically understood the scope of the right to keep and bear arms. Second, the analysis must focus on analogical reasoning, not finding perfect historical matches. The Supreme Court clarified this in the recent unanimous Rahimi decision. You don't need an 18th century law that's identical word for word to your modern regulation. What you need is evidence that the principle underlying your modern law is consistent with principles the founding generation would have recognized. If they regulated a certain category of dangerous conduct, modern legislatures can regulate that same category even if the specific mechanisms are different. Third, and this is critical, the historical tradition must be relevant and probative. You can't cherry-pick one outlier law from 1792 and claim it establishes a tradition. You need a pattern of regulation that shows the founding generation actually understood the right to bear arms as having this particular limitation. Courts must look at the scope of the historical restrictions, how they were applied, and whether they were widely adopted or just isolated experiments. Here's why this emergency order matters right now. 11 other states have laws that are substantially similar to the one the Supreme Court just stayed. Those laws ban categories of semi-automatic firearms based on feature tests, and they impose magazine capacity restrictions. Every single one of those laws just became significantly more vulnerable. Plaintiffs challenging those restrictions now have Supreme Court language they can cite, showing that the nation's highest court believes these types of bans likely violate the Second Amendment. Federal judges who were uncertain about how to rule on pending challenges now have clear guidance. The Supreme Court has indicated these feature-based bans don't align with constitutional protections. That doesn't mean every similar law will automatically be struck down, but it does mean the legal landscape just shifted dramatically in favor of gun rights advocates. We're already seeing movement. Within 72 hours of this emergency order being issued, 2 federal district courts cited it in preliminary injunction hearings involving similar laws. One judge specifically stated that the Supreme Court's language about likelihood of success weighs heavily in favor of granting relief to plaintiffs. California is defending both a feature-based assault weapon ban and a magazine capacity limit. Those cases are at various stages in the Ninth Circuit, and plaintiffs have already filed emergency motions asking for stays based on this new Supreme Court order. The argument is straightforward. If the Supreme Court believes similar laws in another jurisdiction likely violate the Second Amendment, California's laws face the same constitutional infirmity and should be stayed pending final resolution. Maryland, Massachusetts, Connecticut, and New Jersey all have substantially similar laws. Each of those states is facing federal lawsuits. And each of those lawsuits just got significantly stronger. We're already seeing judges schedule expedited hearings. We're seeing magistrate judges issue recommendations that district courts grant preliminary injunctions. We're seeing states file emergency motions asking for en banc review before 3-judge panels can rule. The legal ground is shifting in real time. The law the Supreme Court stayed also banned any magazine capable of holding more than 10 rounds. This component of the law is facing its own constitutional reckoning. And this emergency order just accelerated that timeline. Standard capacity magazines for many common handguns hold 15 to 17 rounds. Standard capacity magazines for common rifles, like the AR-15, hold 30 rounds. These aren't exotic high-capacity devices. These are the magazines these firearms are designed to use, and the magazines that are sold with them from the factory. More than 100 million magazines that hold more than 10 rounds are currently in circulation in the United States. Law-abiding citizens own them for home defense, for sporting purposes, for training, and for competition shooting. Under the framework the Supreme Court has now reinforced, the Second Amendment protects arms in common use for lawful purposes. When 100 million of something exists and millions of Americans use them without incident every day, that's the definition of common use. The state defending this law argued that limiting magazine capacity reduces casualties in mass shooting events by forcing shooters to reload more frequently, but the Supreme Court's emergency order suggests that argument isn't sufficient to overcome the constitutional problem. The question isn't whether a restriction might have some theoretical public safety benefit. The question is whether that restriction is consistent with historical tradition. When the Second Amendment was ratified, the most common firearms were single-shot muskets, but repeating firearms existed. The Girandoni air rifle could fire 22 rounds without reloading. The founding generation knew about higher capacity weapons, and they didn't restrict them. The constitutional tradition was that citizens could possess arms with the same capacity as military or defensive forces of the era. Fast forward to today. Law enforcement officers carry handguns with 15 to 17 round magazines because that capacity is considered standard and appropriate for defensive use. If a trained police officer needs 15 rounds to adequately defend themselves and others, why would a law-abiding citizen facing a home invasion need less? The Supreme Court's language about likelihood of success suggests they find this disparity constitutionally problematic. This emergency ruling just changed the calculus in at least 18 active federal cases challenging similar laws across the country. Plaintiffs who were waiting for their cases to move through district courts now have powerful Supreme Court language to cite. Judges who were uncertain about how aggressively to apply the Bruin framework now have clear signals. And states defending these laws just saw their strongest legal arguments undermined by 8 Supreme Court justices. But here's what makes this particularly significant. Some of these cases have been stuck in procedural limbo for years. Courts were holding them pending other decisions, waiting for more guidance, or slow-walking the litigation because judges were uncertain how to apply Bruin's framework to these specific restrictions. This emergency order just removed the uncertainty. The Supreme Court has signaled how they view these laws, and lower courts now have clear direction. State lawmakers who passed these restrictions, believing they were carefully threading the constitutional needle, just received a wake-up call. The Supreme Court didn't just stay one law in one state. They provided a roadmap showing that an entire category of gun regulations is constitutionally suspect. And that's forcing legislators to make difficult decisions about whether to defend these laws in expensive litigation they're now likely to lose, or whether to repeal or modify them before courts strike them down. Several state legislatures are already convening emergency sessions to discuss their options. Some legislators are arguing they should double down and defend their laws vigorously, forcing the Supreme Court to issue a full opinion that definitively resolves these questions. Other legislators are arguing that's throwing good money after bad, and that states should preemptively revise their laws to focus on restrictions more likely to survive constitutional scrutiny. Here's what happens next in the specific case the Supreme Court just stayed. The case goes back to the district court for a full hearing on the preliminary injunction. The district court must now evaluate the law under the Bruin framework, and the court must do so with full knowledge that the Supreme Court believes the plaintiffs are likely to succeed. That makes it very difficult for the district court to rule in favor of the state. Assuming the district court grants the preliminary injunction, which now seems highly likely, the state will appeal again. The case goes back to the same appeals court that created this problem in the first place. But now that appeals court has been unmistakably told by the Supreme Court that their previous analysis was wrong, they'll have to reconsider. The realistic timeline for final resolution is 18 to 24 months. That might seem like a long time, but in the world of constitutional litigation, that's remarkably fast. And during that entire period, the law cannot be enforced because of the stay the Supreme Court just issued. Millions of gun owners in that state can continue possessing the firearms and magazines they legally purchased. Step back and look at the bigger picture of what's happening. In just over 2 years, we've had the Bruin decision establishing the historical tradition framework, the unanimous Rahimi decision clarifying how that framework should be applied, and now this 8-1 emergency order demonstrating that the Supreme Court will actively intervene when lower courts deviate from that framework. This is a Supreme Court that is unified in its view of how the Second Amendment should be interpreted, and that is willing to use every tool at its disposal to ensure that interpretation is followed. This doesn't mean all gun regulations are now unconstitutional. It means the universe of permissible regulations is now clearly defined by historical tradition. Background checks have historical precedent. Restrictions on possession by dangerous individuals have historical precedent. Prohibitions on carrying firearms in truly sensitive locations like courthouses have historical precedent. But feature-based bans, capacity limits, and sweeping sensitive place restrictions that encompass half of public space, those don't have historical precedent. And this emergency order reinforces that those types of laws are in serious constitutional jeopardy. The legal landscape just shifted dramatically. 8 Supreme Court justices made sure of that. And what happens next will determine whether states adapt to this new constitutional reality or whether we're headed for even more definitive Supreme Court interventions that settle these questions once and for all.